we have another case in 2007. Now the problem with monsoon, just for your information, Malaysia practice common law system. What it means is other than the statute, you still have to look at decided case. All right, there's a doctrine of judicial precedent. It means that a decision of a higher court will be binding on the lower court. So we have problems there. That means that under this Latin word called stare decisis, we have to actually follow what is decided on top of us. Right? We have this case in Ao Ming Nam versus Ong Yak Chiu. So just remember this is the Ao case. So what happens is this case go all the way up to Court of Appeal. Where is Court of Appeal? Court of Appeal is the second in the hierarchy. The higher is Federal Court. Alright? So what happened is that they face a problem. I have a Federal Court telling me that, you know, in Adorno case it's like that. So what do I do? So let's look at the facts of the case. Again, two imposters. So we all deal with imposter here. Claiming to be the owners of the land and enter into sales and purchase agreement with the first defendant using a forged title. Like this case, it's a forged title. It's not a replacement title, right? The real owner subsequently came to realize that their land had been transferred to the first defendant and sued for the return of the land. Okay, so they are like Bonsun as well. The difference between this and Bonsun is very simple. Number one, that is a replacement title. This is a forged title. Okay. So in the final decision, the Court of Appeal observed that the registration of title to the plaintiff was obtained by forgery. Therefore, it was indefeasible. What does it mean? They are applying Section 3402. So it means because there's tampering or forgery involved, therefore, the other person who buys the first purchaser cannot have a good title. But they have problem because they cannot ignore what is laid down in Adorno Properties in 2001, okay? Due to the doctrine I told you just now, where you have to follow. But later, what happened is that they try to distinguish it and see how they can apply back Section 340. So what they say is this. Now, they say that a purchaser who concludes an acquisition without a proper investigation to the title, or the person claiming to be the owner cannot claim to be a purchaser in good faith. Now, just to let you know, this case is easier to do. You know why? Because the first buyer, in this case, the first purchaser, rushed the transaction because he thought he got a good deal. Alright? So you quickly go and never do land search, never do anything, and he also instructed the lawyer to expedite. Okay, so that's one. Number two. Now he or she has an obligation to investigate the property or matter related to the transaction and cannot blindly accept what is claimed by the supposed owner to be genuine. You are not entitled to rely on the representation of the person who sells you the land. Okay, that's very key. If the person who sells the land tells you, you still have to do due diligence. This is what has been laid in the law, is that it's upon you to do your due diligence. If you cannot prove that, it might affect you later. Now, what's the second principle in Ao? In the case of Ao, what happened is that they also laid out a second principle. They said that where a purchaser relies on Section 3403 to contend that it's a bona fide purchaser for valuable consideration, the evidential burden fall on him. See, just now we keep saying that Adorno will come back and say that, oh yes, I'm a bona fide purchaser and all that, and then they are sort of like shifted to Bonsun to prove Adorno is not a bona fide purchaser, it's not buying for value. So what I'm trying to tell you is that in this case they said actually the duty for all intent and purposes shall be with the purchaser to prove he's innocent. Okay? So in this case, it is not for the original owner to prove fraud or forgery, alright, but it's for the person who buy it. Okay, just to let you know where is the fairness in this level, alright? For information, it is very important because, let's put it this way, if in the case of imposter, there's no way the original owner would know. So he would have no control over the transaction, yes or not? If you are the original owner, right? In both these cases, because you have imposter, someone pretend to be you, yes? But in all these cases, there's someone who can control this and end up being sued, which is the purchaser, right? So it is therefore the duty shifted to the purchaser because they have a little bit more control. That is why they distinguish this case from obviously Adona. Other things that inside it said that, just to let you know, like for example, the fact that in Adona there is a genuine title and whatnot, make it perhaps more acceptable. In this case, it's a forged title. So that's the common law situations. Implications: original landowner are now much better or a little bit more protected. The burden now shifted to the purchaser to ensure the acquisition of property is genuine. But I must highlight to you, these have not gone back to the federal court yet, i.e. because the case of Ong ended in Court of Appeal. No one bring that case up to challenge. Because if ever at that time the first purchaser, if they want to challenge and bring it up to the federal court, then the federal court have a chance to actually undo what happened in Adona. Now, first of all, I'm not sure whether the federal court agreed that Adona should be undue, but it should be logically undue. So what happened is that there's no chance. Okay, so it doesn't go up there. So we have to be still very mindful with Adona. Okay, of course you can leave all this to the advice of your lawyers, right? As to all this what happened, but being an interested investor in property, you must be very careful as to whether